Don't you think that the human rights bodies that scrutinize the work of security forces in countries must also be brought under the scanner? It's time to ask them how they go about doing this assessment and how logical are the conclusions. Agree? Great. Let me begin then. Let's take up the 2018 report of the Office of the High Commissioner for Human Rights on Jammu and Kashmir for a counter scrutiny. Here goes. A quick preview of the video next week before I commence. I feel that there is a misunderstanding about how security forces uphold human rights. Therefore, in a follow-up to this video, I will explore the measures and procedures that are implemented by the Indian Army to safeguard human rights. Alright, back to the subject of this video. As a brief backdrop, the appointment of the High Commissioner for Human Rights was actually created on December 20th, 1993. The Commissioner and his office hold the responsibility to promote and protect all human rights. Last year, they came out with a report which dealt with Jammu and Kashmir, and I have fundamental differences with the methodology adopted and the findings that were released in the report. I will therefore briefly touch upon both these issues. Let me begin with the methodology of the report. Now, the report says that the OHCHR, this is the organization, has undertaken remote monitoring of the human rights situation, and this is a quote. The question that arises is, what exactly is remote monitoring? It implies that the report, and I quote, largely draws on information that is mostly available in the public domain. And again I quote, it was not possible for OHCHR within the time frame available for producing this report to use direct witness testimony. Quotes closed. This implies that the observations made in the report are not fully validated, and if I may add, could well have been sourced from questionable sources. Despite this, the High Commissioner, presumably a person of high regard, capability and standing, chose to still go ahead with, if I may use the term, a half-baked report. Now, the OHCHR itself affirms in the report that since they did not have access to Kashmir, it bases its findings on its methodology using a reasonable grounds standard of proof. So therefore, are we also expected to read its findings and conclusions within reasonable grounds of suspicion? Now, in light of my reasonable grounds of suspicion, let me examine some of the findings. So the first statement reads that the Armed Forces Special Power Act 1990, AFSPA as it's commonly known, effectively bestows immunity from prosecution in civilian courts for their conduct by requiring the central government to sanction all prospective prosecutions against such personnel prior to being launched. Now, this is the quote from the report. This is yet another half-truth or half-lie, depending upon how we want to look at it. Existing Indian laws allow the army an option to take over cases or allows them to be prosecuted in civil courts. This is as per the law. Need an example of the latter? Contrary to what the report says, there is a case of Major Kishore Malhotra, now a brigadier, which continues to run in the civil courts over all these years. And the protracted conduct of such proceedings will tell you why the army insists on taking over its cases. Second, the cases which are tried within the army can be appealed against in a civil court. The Armed Forces Tribunal and the Supreme Court are both, mind you, empowered to hear appeals against army court verdicts. Therefore, the logic of civil courts not being linked with the process is flawed. Third, there are reasons for military courts to try such cases, and these are no different in India as compared to other countries like the UK and the US, countries which have been deployed in CIA operations. This is especially relevant in India's case, where cases in civil courts can undergo a very long cycle, unlike some other countries. Now, some of the reasons for the same, that is taking over cases, are: 1. Military courts provide far quicker justice. 2. They weed out false cases expeditiously, which is something which happens quite commonly. Finally, there are any number of cases where military courts find that the accused is in fact guilty, whereas they are able to circumvent the civil judicial system to go scot-free. So the logic of impunity is actually misplaced. Lastly, we come to the question that actually begs to be answered: can we as a nation afford to have a large number of our officers and soldiers busy fighting their court cases? Who will do the fighting with the terrorists and the enemy then? I think this is food for thought. Let me move to the next statement. It reads, and I quote, "In responding to demonstrations that started in July 2016, Indian security forces used excessive force that led to unlawful killings and a very high number of casualties." The quote closes here. So what exactly does excessive force imply? Can the OHCHR please tell me, since they obviously seem to understand it? In light of the judgment, can they also let me know about the weapons or actions that are not excessive for J&K? Should security personnel be restricted to the use of batons, water cannons, tear gas, and in the process allow a few cornered policemen to be lynched, as has happened in some cases? Allow their vehicles to be pushed into a river only to drown, as has again happened in the past? Be hit repeatedly by a mob outside a religious place until their very death, again, as has happened not too long ago? So what exactly is excessive force? Now, let me explain it to you, at least from my perspective. The Indian security forces are amongst the only ones in the world who, despite taking casualties, refuse to employ air power in an offensive role or use armed drones, artillery fire, heavy caliber weapons in counterterrorism operations. If this is indeed the case, I don't get the basis for describing actions as excessive force under the prevailing conditions. Now, since we've spoken of prevailing conditions, let me come to the circumstances under which the forces get applied. The report incorrectly describes some of the victims as merely stone-throwing people. In reality, sections of the population have been subverted to not only disrupt ongoing lawful counterterrorism operations, they have also facilitated the escape of hold-up terrorists. Given this reality, this is how it can be described in legal terms. According to section 1073 of the Indian Penal Code, these actions could be classified as abetment, which is defined as, and I quote, "when either prior to or at the time of commission of an act does anything in order to facilitate the commissioning of the act and thereby facilitate the commission thereof, is said to aid the doing of the act." Now, if someone really wanted to seek human rights violators here, then it is the Hurriyat Conference, which issues protest calendars very regularly, despite knowing the possibility of unfortunate consequences of such acts. It is Pakistan which subverts an entire section of the population. I think we need to place the reality in the right context. To conclude, let me offer a word of advice to such organizations. First, please do not create a laundry list of unfounded litanies without being able to back it. 2. Ask yourself why states reject your reports out of hand. Not because they do not care for human rights, it is because your approach is not objective. If I may suggest, for once, try handing over such reports in person to those who can actually make a difference. Be a part of a group that sensitizes the environment, including the security forces. Facilitate better understanding of human rights. And finally, stop your remote monitoring and try for once to gain a first-hand understanding of the ground reality.